Brexit's a political event of enormous significance. I don't think that's a controversial proposition. It has the potential to fundamentally change the nature of the United Kingdom, and at the same time that change is a fundamentally uncertain one. What tensions will arise in the process of Brexit? How will Brexit change the relationship between the state, the individual and markets? Will fundamental rights like data protection be lost or weakened? And in what ways will the UK and the EU continue to interact around information law and data protection in particular? Understandably and properly, the core conference focus is on navigating the immediate aftermath of GDPR. We're thinking about the art of the possible. But I want to think a little bit about what are the possibilities if adequacy goes wrong. What are the different potential futures that might exist? My own research looks at the public-private divide in information law, part of which is an intense focus on data protection. To what extent and why have public authorities and private actors been subject to different standards over time? And how has that changed? And so the development of thinking around adequacy and the ways in which the UK might diverge should adequacy not be successful feed into that broader picture. And so I want to explore those questions first by looking at the short-term tensions around adequacy, drawing on some of the excellent discussions from this morning, and what that might mean for the public-private divide in an adequacy Brexit. And then secondly, I want to explore those questions in a potential future in which the UK lacks an adequacy decision. So what would a post-adequacy Brexit potentially look like? Examining those, I don't think, is merely a matter of academic interest. It's important to reflect on the tensions that will be present in the alternative possibilities that the law might take, what's potentially at stake, who might therefore argue for those futures. Now, I don't want to give the suggestion that I think these are equally likely future scenarios. I think there's a very high chance of an adequacy Brexit, and there are great strengths and benefits to that. But in order to understand what would be gained or lost, it's important to reflect on those broader options. I also think it's important because the last few years have really demonstrated that we should be cautious to say that will never happen, and therefore we should reflect on the good and the bad. So data protection immediately post-Brexit, the sort of adequacy Brexit model. There will be short-term tensions between the UK and GDPR post-Brexit. The draft withdrawal agreement that was published in February 2018 makes limited reference, I think, to data protection. So in particular, Article 68 of that draft, that union law on data protection will apply to the United Kingdom in respect of processing of data subjects outside the United Kingdom, provided that that personal data was processed in accordance with union law before the end of any transition period, or are processed after that transition period on the basis of the withdrawal agreement. So only limited amounts of personal data would be covered by the envisaged draft. That therefore doesn't alter the fact that the UK is likely, well, will become a third country on either the expiry of 2 years post notification or any period that's set as a transitional period. The European Union Withdrawal Bill currently provides for the incorporation of directly effective EU legislation post-Brexit, but significantly hasn't made provision for the Charter of Fundamental Rights to be incorporated, although that's a subject of a to and fro. All of those aspects of the law and planning around Brexit remain therefore subject to great uncertainty.